Common law. To understand the common law, we begin with the original definition from Hale's History of the Common Law, which states that the common law is a common rule for administering justice within this kingdom, and asserts the king's royal prerogatives and likewise the rights and liberties of the subject. It is generally that law by which the determinations in the king's ordinary courts are guided. It directs the course of descendants of lands, the nature, extent, and qualifications of estates, and the manner and ceremonies of conveying them from one to another, with the forms, solemnities, and obligations of contracts, the rules and directions for the exposition of deeds and acts of Parliament, the process, proceedings, judgments, and executions of our courts of justice, the limits and bounds of courts and jurisdictions, the several kinds of temporal offenses and punishments. In more modern and familiar language, the common law includes all those laws which do not derive their origin from acts of Parliament, but from long custom and use, ascertained from the records of our courts of justice, from reports and judicial decisions, and from the treatises of distinguished men handed down from high antiquity. And to better understand common law, it is actually important that we look at things which it is opposed to. It is contrasted with statute law, as law not promulgated by the sovereign body. It is contrasted with equity, as a law prevailing between man and man, unless when the Court of Chancery assumes jurisdiction. And it is contrasted with local and customary law, as a general law for the whole realm, tolerating variations in certain districts and under certain conditions. It is also sometimes contrasted with civil or canon or international law, which are foreign systems recognized in certain special courts only and within limits defined by the common law. As against all these contrasted kinds of law, it may be described broadly as the universal law of the realm, which applies wherever they have not been introduced, and which is supposed to have a principle for every possible case. Occasionally, it would appear to be used in a sense which would exclude the law developed by, at all events, the most recent decisions of the courts.